Good morning, ladies and gentlemen. I'd like to welcome you to County Court at Law Number 2. My name is Judge Terrence Holmes. I'm the presiding judge here in County Court at Law Number 2. You have been asked to come to court today for what we call an arraignment. And what the arraignment is, it's an opportunity for the court to tell you what you've been charged with, what your rights are, and what your options are concerning your case. Now, the case that you have in this court is a criminal case. Criminal cases are divided into felonies or misdemeanors. We handle misdemeanors. Your felony cases are referred to as your more serious type of offenses, whereas your misdemeanor cases are referred to as your petty offense. Does not mean that they're not serious, just means that they're not as serious as a felony case. And when I use the term serious, what I'm talking about is I'm talking about the facts of the case and the possible punishment that a person can receive if they are convicted of the offense. Now, felony cases are divided into 5 categories. We'll start at the top and work our way on down to the bottom. You have the capital murder, first-degree felony, second-degree felony, third-degree felony, and state jail felony. If a person is convicted of a state jail felony, the range of punishment is minimum 6 months to a maximum of 2 years in the state jail and a fine that does not exceed $10,000. If a person is convicted of a third-degree felony, the range of punishment is minimum 2 years to a maximum of 10 years in the state penitentiary and a fine that does not exceed $10,000. If a person is convicted of a second-degree felony, the range of punishment is minimum 2 years to a maximum of 20 years and a fine that does not exceed $10,000. If a person is convicted of a first-degree felony, the range of punishment is a minimum 5 years to a maximum of 99 years to life and a fine that does not exceed $10,000. Now, if a person is convicted of a capital murder, which is the highest felony offense, the range of punishment is minimum life in the state penitentiary without the possibility of parole or death by lethal injection. Now, you don't have to worry about that, those punishments, because as I mentioned earlier, your offense is classified as a misdemeanor. And misdemeanors, they have 3 categories. We'll start at the top, work our way on down to the bottom. You have the Class A misdemeanor, the Class B misdemeanor, and the Class C misdemeanor. If a person is convicted of a Class C misdemeanor, the range of punishment is by fine only. The fine is usually from $0 to $500. And these misdemeanor, Class C misdemeanors are cases that originate or start in the city court, which is the municipal court, or the JP court, which is the justice court. Now, they get to this court when a person is convicted in the JP court or the city court, and then they appeal their case. And then the case comes to this court by way of an appeal. Now, if a person is convicted of that Class C misdemeanor in this case, or in this court, the range of punishment does not change. It's still minimum $0 to a maximum of $500. Now, if a person fails to pay the fine and court costs, or if the fine and court cost was converted to community service and the person failed to perform the community service, then the court can issue what is called a capias pro fine. It's a warrant for the arrest to pay the fine or sit out the fine in jail. Now, a person can receive $100 credit for every day that they spend in the jail. Now, the next highest misdemeanor is a Class B misdemeanor. The range of punishment for a Class B misdemeanor is minimum 0 days to a maximum of 180 days in the county jail, or a fine that does not exceed $2,000, or a person can be given both such fine and confinement. If a person is convicted of a Class A misdemeanor, which is the highest misdemeanor, the range of punishment is minimum 0 days to 365 days, which is a year in the county jail, or a fine from $0 to $4,000, or they could be given both such fine and confinement. Now, a person may be eligible for probation. There are 2 types of probation. One type of probation is called adjudicated probation, and the other type of probation is called unadjudicated probation. Now, the difference between the two is as follows. With the adjudicated probation, you will have a conviction on your record. However, if you successfully complete the probationary period, the court can grant what is called a judicial clemency. What that means is the court can set aside your conviction. And if the courts, in order to qualify for judicial clemency, you have to complete the probation. There cannot be any more time left on the probation, and you have to be successfully discharged from the probation. If those three things happen, then the court has the discretion to set aside your conviction, which means you will not have a conviction on your case. However, if you get a subsequent conviction, that is, if you get another conviction later on, then the court can, your case can be resurrected, revived, and brought back up and used against you. And if you try to get a license with CPS, they could either deny giving you a license, or if you have a license, they can revoke or suspend that license. Now, the other type of probation is called unadjudicated probation. With unadjudicated probation, you don't have a conviction on your record. And if you successfully complete the probation, the case will be dismissed. It will not result in a conviction on your record. And you may be eligible for a non-disclosure. And what a non-disclosure is, basically your record is sealed to the general public. Now, notice I use the word general public. That's because certain governmental agencies can have access to it. For example, like the police department, DA's office, and different governmental agencies that are listed in the Texas Code of Criminal Procedure. They can have access, but most of the public is the general public. So most of the public cannot have access to your record if you get a non-disclosure. Now, as a defendant in a criminal case, you have rights. One of the rights that the first right that I'm going to talk about is your right to have an attorney. Now, the clipboard that you have before you, on that clipboard, there are several documents. One of the documents is Judge's Explanation of Rights to Defendants Without an Attorney. There's another document, it should be the second document that's on that clipboard, that is Waiver of Counsel for Purposes of Entering a Guilty Plea. And then the third document that's on the clipboard is Jefferson County Affidavit of Indigence. Now I'm going to go over those documents with you so I can explain to you how those documents are to be used. Now, the first document is a Judge's Explanation of Rights to Defendants Without an Attorney. Now, as a defendant in a criminal case, you have a right to have an attorney. Now, regarding your right to have an attorney, you have three options. Number one, as listed, you may hire an attorney. That's your first option. Number two, if you do not have enough money to hire an attorney, you may request that an attorney be appointed to represent you. Or number three, you may represent yourself. Now, if you want to have an attorney to represent you and you have enough money to hire an attorney, your case will be reset. Reset means that you will be given another court date so that you will have time to hire an attorney. If you want an attorney, but you do not have enough money to hire an attorney, then you will have to first fill out a financial questionnaire. And the financial questionnaire is the Affidavit of Indigence, the Jefferson County Affidavit of Indigence that's on the clipboard. You would have to fill out the first page of that document and half of the second page. I will fill out the bottom half and the third page. Now you'll fill out that document, then the proper person will determine whether or not to appoint an attorney to represent you, depending on whether or not you're eligible. If you want to waive your right to an attorney, which means you want to give up your right to have an attorney and you want to represent yourself, then if you do that, you'll have an opportunity. Actually, you'll be representing yourself. And so you'll have an opportunity to talk to the district attorney or the assistant district attorney or the prosecutor yourself, because at that point, you will be representing yourself. And that's, you'll be acting as your own lawyer. Now, before you can talk to the assistant district attorney or the prosecutor, you have to first sign a waiver. The waiver is waiving your right to have an attorney. The waiver is titled Written Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. That document is on that clipboard. I'll go over that document with you in a few minutes. Now, you should be aware that there are dangers and disadvantages to self-representation. Waiving your right to an attorney and representing yourself may result in a worse outcome for you, including the right to have a firearm, the right to enter into the military. It may involve losing housing and public benefits, child custody, immigration status for non-citizens, and employment. Now, if you choose to waive your right to an attorney, you may request that an attorney be appointed to represent you. Okay? Now, at the bottom of the document that is titled Judge's Explanation of Rights of Defense Without Attorney, you'll see 5 lines to the left at the bottom. If you want to hire your own attorney, then you'll place your initials on the first line to the left. If you have already hired an attorney to represent you, then you'll place your initials on the second line to the left and the name of the attorney on the line to the right. If your choice is to waive your, if your choice is to request that an attorney be appointed to represent you, then you will place your initials on the third line to the left. If you've already been appointed a court-appointed attorney to represent you in this case, then you will place your initials on the fourth line to the left. If your choice is to waive your right to an attorney or give up your right to have an attorney, and you would like to represent yourself, then you will place your initials on the fifth line to the left. Now, once you have finished initialing one of the 5 lines at the bottom of this document, you will sign your name on the line that is titled Defendant, and you will date it today's date, August 13th of 2024. Now, for those individuals who will be waiving their right to an attorney and representing themselves, you have to read and sign the document that is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. And I'm going to go over this document with you, and it states as follows. I have been advised of the nature and charges against me and the dangers and disadvantages of self-representation. My waiver is voluntarily and intelligently made. Now, when we use the term voluntarily, what you're saying is no one is forcing me to waive my right. I'm doing it of my own free will. And intelligently, when we use that term, we say, I know what I'm doing. So it says my waiver is voluntarily and intelligently made. Furthermore, I have been advised this 13th day of August of 2024 by the County Court at Law, number 2, of my right to have representation in the case pending against me. Now, I have been further advised that if I'm unable to afford counsel, one will be appointed to me free of charge. Now, understanding my right to have an attorney appointed to me free of charge, if I'm not financially able to employ one, I wish to waive that right or give up that right and request that an attorney and request that the court proceed with my case without an attorney being appointed to represent me. I hereby waive my right to counsel. And if that is your choice, for those individuals who will be representing themselves, you will sign your name on the line that's titled Defendant, and you will date it today's date. And today's date is August 13th of 2024. Now, for those individuals who will be requesting that an attorney be appointed to represent them. You would have to, as I mentioned earlier, read the document that is titled Jefferson County Affidavit of Indigence, and you would have to fill out the top portion where it's asking for your name, your address, your phone number, whether or not you receive any type of governmental benefits. If you do, you'll check one of the 5 boxes, and it's asked whether or not you're unemployed. If you are employed, just state where and what type of work is it, how many hours you work, how long you've been working there, and they ask for your marital status, whether you're single, married, divorced, widowed, or separated. And if you're married, you write your spouse's name. Now, below that, it asks for names of any dependents or children. Any children from age of 0, well, from the age of 18 on down. And so you write their name and their ages. And then below that, where it says residence information, you're going to circle whether or not you're renting, whether you own a home, reside with family, or whether you're homeless. And then at the bottom left side of the document, it talks about monthly income and assets. So if you are working, they just want to know what you're taking home a month. Not what you're grossing, but what your net is, what you're taking home. Now, if you're not working, it'll be 0. Now, if your spouse is working, you can put what she's taking home per month. If you receive child support, you put that down each month. If not, 0. If you receive any type of food stamps, which is SNAP, you put that down a month. If not, it's 0. Social Security, if you receive it, you put that amount down. If not, it's 0. If you receive any type of governmental checks, you put that amount down. If not, it's 0. Or other income is 0. If you have any assets like a car, a house, etc., then you'll put the value of that, and then you'll total it at the bottom. Now, on the other side at the bottom, where it says monthly expenses, you will place where we have rent. If you're paying rent or mortgage, you put whatever you're paying per month. Utilities, that's electric, gas, water, you'll total that up and put it per month. If you have child expenses, that's not only just child supported, but if you have to pay buying school supplies, clothes, food, or whatever for children, then you'll put that amount, total that amount in the category where it asks for total child expenses. Now, your food expenses, that's for the house. Total food expenses will go there for the month. Transportation costs. Now, when we get to transportation costs, we're not only asking for how much gas you are paying, what are you paying for gas and oil a month, but also if you're paying a car note and if you're paying car insurance. You add all of that up, that's going to be your total transportation cost. Now, if you do not have a car note, but if you take an Uber or you're paying somebody to take you to work, then you're going to put that amount there. Now, if you have a cell phone or home phone, you're going to put the monthly expense for the home or cell phone. If you have probation fees, or if you have parole fees, or if you're paying a bondsman, I think you can put that where it says probation fees. Now, medical expenses, if you have medical expenses or health insurance, you're going to place that on there that you're paying per month. And if you have a credit card, you're going to put what your minimum monthly credit card payment would be on that. And then you're going to add all of those expenses up and you're going to total it. Now, when you get to the second page of the affidavit of indigence, at the top it says defendant's oath. You're going to read that, you're going to date it, and then you will sign where it says defendant's signatures and date. Then you're going to go to unsworn declaration, which is at the bottom of the document. You're going to fill that information out with your name, first, middle, and last name, your date of birth, your address, city, state, zip code, and the country, which is USA, and then U.S. state, where it says, I declare under penalty of perjury that the foregoing is true and correct. Executed in the blank is supposed to be Jefferson County, state of Texas, on the 13th day of August 2024. Okay. Now, and then once you fill all those documents out, we'll review those documents. We'll have you come up. Now, as a defendant in a criminal case, you not only have a right to have an attorney, but you also have a right to have a trial by jury. Where that young lady is sitting in that area, we call that the jury box. And 6 citizens from Jefferson County will be selected if you decide to have a jury trial. They will be selected to listen to all the evidence. They will listen to all the arguments. They will deliberate, and they will decide whether or not to find you not guilty or guilty of your charge. You also have a right to waive, which means to give up your right to have a trial by jury. And if you waive or give up the right to have a trial by jury, you will not be having a trial by jury. However, your case will come before the court or the judge in one of 3 ways. One way it can come before the judge is by way of a bench trial. That is, you'll have a trial where the judge will be the judge and the jury in the case. It's a trial without a jury, but it's a trial with the judge as a judge and the jury. And the judge will listen to all of the evidence, listen to the arguments. The judge will decide whether to find you guilty now or not guilty after applying the facts of the case to the law. Next, you have a right to, the next way that your case can come before the court is by way of a plea bargain agreement. It can come by way of an agreed plea bargain agreement. What a plea bargain agreement is, it's an agreement that you work out with the state to settle your case. We call that a plea bargain agreement. For example, you and the state might work out a plea bargain where the state said, well, we're going to offer you probation or defer probation. And you say, I accept it. So that's the plea bargain agreement. Or they might say, well, we'll give you 1 day in jail. You say, well, I accept it. That's an agreement. Now, if you work out a plea bargain agreement, an agreed plea bargain agreement, then your case will come before the judge, before me. And the judge can do one of 2 things. The judge can accept your plea bargain agreement or reject your plea bargain agreement. Now, if the judge rejects your plea bargain agreement, you have a right to take your plea back. So, for example, let's say the judge, let's say you're in the state work out a plea bargain agreement for probation, and it comes before the judge, and the judge says, well, I'm going to reject that plea bargain agreement. I'm not going to follow. You can say, well, judge, since you're not following my plea bargain agreement, I take my plea bargain back. In essence, I'm not pleading guilty and I'm not pleading no contest because you have a right to do that. If the judge doesn't follow the plea bargain agreement, does not accept the plea bargain agreement. Now, if the judge accepts the plea bargain agreement and you decide like in 30 days, you say, I think I've been wrongfully convicted or the court committed an error by convicting me. I want to appeal my case. In essence, I want to have a higher court to review my case to see if I've been wrongfully convicted or if the judge or if the court committed an error by convicting me. Well, if the judge follows the plea bargain agreement and you want to appeal, you have to get the judge's permission to appeal. And if the judge gives you permission to appeal your case, then your case is going to leave this court and go up to the Ninth Court of Appeals, which is on the 3rd floor, and they will review your case. They can do one or 2 things. They can either grant or deny your appeal. If they grant your appeal, then they can simply find you not guilty. Or if they deny you, or they can send the case back down to this court and order this court to give you a whole new trial. Now, if they deny your appeal, you can appeal it to a higher court than the Ninth Court of Appeals. You can appeal it to the highest criminal court in the state of Texas, which is called the Texas Court of Criminal Appeals. It's located in Austin, Texas. You would have to file what is called a pro se petition for discretionary review. I'm going to explain what that means. Pro se means you're representing yourself. You don't have a lawyer. You'll be filing your own petition to the Texas Court of Criminal Appeals, asking them to review your case. Now, if they can do one or 2 things. They can grant your pro se petition. If they grant your pro se petition, then at that point, they can simply find you not guilty, case over. Or they can send the case back to the Ninth Court of Appeals with orders, or they can send it back down here to this court and order us to give you a whole new trial, or order us to give you a whole new trial. Now, the other thing is, If they deny your pro se petition, then at that point, your conviction will stand. Now, the last way that your case will come before the judge, besides a bench trial or an agreed plea bargain agreement, is by way of an unagreed plea bargain agreement. That is, you and the state have not been able to reach an agreement concerning your case, but you want the judge to assess the punishment to say what your punishment is going to be. We call that unagreed. Now, once it comes before the judge assess your punishment within the punishment range. Now, the other right that you have is, besides having the right to have an attorney, right to have a jury trial, the right to have a bench trial, the right to enter into an agreed plea bargain agreement or an unagreed plea bargain agreement, you have a right to have witnesses to come to court. And what witnesses do, they can testify. They testify either for you or against you. And if you represent yourself, you can ask some questions. Or if you have an attorney representing you, your attorney can ask some questions. We call that either direct examination or cross-examination. Now, you also have a right, we call that you have a right to waive your right to have witnesses, meaning that you have a right not to call witnesses. Now, if you waive or give up your right to call witnesses, that means you will not be calling witnesses. It does not mean that the state or the district attorney will not be calling witnesses, because they will be calling witnesses in the case. Now, you also have what is called a Fifth Amendment right against self-incrimination. I know on television we hear people saying, hey, I take the fifth. What that means, I'm not saying nothing. Why? Because I have a right on the United States Constitution, the Fifth Amendment of the United States Constitution, not to say anything. So I'm invoking my Fifth Amendment right not to say anything. So if you have a right to take the fifth, you have a Fifth Amendment right against self-incrimination. What that means is the district attorney, the state, or the government cannot force you to take the witness stand. Okay? They can't call you as a witness if you exercise your Fifth Amendment right against self-incrimination. Now, you can waive or give up your Fifth Amendment right against self-incrimination. Now, if you waive or give up your Fifth Amendment right against self-incrimination, that simply means that you will be taking a witness stand. Now, you also have a right to have what we call discovery. Discovery means that you have a right to see the evidence that the state has against you. In essence, if the state has a file, you have a right to review the file, or you have a right to see what the state is using against you. And for example, you have a right to see your statement, witness statements. You have a right to see police reports, lab reports. You have a right to listen to audio recordings, to see video recordings, photos, and any instruments that the state may have. You have a right to have access to it. We call that discovery. Now, you also have a right to waive or give up your right to have discovery, which means you have a right not to have access to anything. You might say, I don't want to see none of that. That's your right. Now, as a defendant in a criminal case, now everyone that's here today, you're here because one, you was charged with a misdemeanor criminal offense, and you've been arrested. However, you're out of jail on bond. You're either out on a cash bond, which means you paid the full amount of the bond to get out of jail. You're out on a surety bond, which means that you paid a bondsman a percentage of the bond to get out of jail, or you're out of jail on a PR or a personal recognizance bond, which means you didn't have to pay no money to get out of jail. You was just released under your own personal recognizance with a promise to appear here in court today. Now, every day that you spent in jail, that jail time can be used towards your punishment. So, for example, let's say you're in the state of reached a plea bargain agreement, and let's say you spent 5 days in jail. And let's say the state is offering you to serve 5 days in jail. That means you don't have to serve any more time in jail because you've already served 5 days in jail. Therefore, you'll be given credit for the time that you've already served. Now, if the state is offering you 7 days in jail and you serve 5, that means you only have to serve 2, because we'll subtract 5 from the 7, and that leaves 2. Now, every day that you spent in jail can also use as credit toward your fine and court costs. You received $12.50. Well, for every day that you spent in jail, it can be used as credit toward your fine and court costs. So every day that you spent in jail, that's $100. Okay? So if you spent 5 days in jail, that's $500 that you have credit toward your fine and court costs. So, for example, if the state is offering you fine and court costs of $500, you spend 5 days in jail, you don't have to pay nothing. Why? Because it's already paid. Okay, so you get credit for the time that you spent in jail, so the fine and court costs will be taxed and retired. And the other thing is, for example, if the state is offering you fine and court costs of $700, you spend 5 days in jail, which is $500. That means you only have to pay $200 because we're going to take the 500 from the 700 and then leaves the 200. Now, you'll be required to pay the $200 balance on the day that you enter your plea. If you cannot pay it, no problem, because we could put you on what is called a payment plan, where you can pay it off so much every month. Now, some people may not have the ability to pay off the money, even if they're put on a payment plan, because they do not have the income. No problem. We can convert the fine and court costs to community service. And with the community service, every 1 hour of community service that you perform, $12.50 will be credited toward payment of the fine and court costs. So if you work 8 hours one day, that's $100. So in the scenario that I gave with $200, you work 2 8-hour days, community service, your fine and court costs is paid. Simple as that. Now, if you haven't been in trouble before, Jefferson County has a program that they will dismiss your case, and you can get it wiped off your record. The program is called pretrial diversion. In order to qualify for the pretrial diversion, you have to have an attorney to assist you with making an application to the DA's office to get into the program. It cannot be an offense for unlawfully carrying a weapon or resisting arrest. And it has to be your first time getting into trouble. So if your first time getting into trouble, you may be eligible for pretrial diversion. And again, they will dismiss the case and you can get it wiped off your record. Now, they have a Jefferson County District Attorney's Office has another program as well, where you can get it off your record. It's called Veterans Court. If you are a veteran of any one of the branches of the United States military, Jefferson County District Attorney's Office has a program for veterans only. You get into the program, you complete the program, they dismiss the case. Once you get the case dismissed, you can qualify for a non-disclosure. And a non-disclosure basically means that your record is sealed to the general public. Okay? So if you're interested in any one of those programs, just let us know. And we have someone from the District Attorney's Office who will be happy to help you and assist you in getting into the program. Now, this court, Jefferson County Court at Law Number 2, has a program that is called the CSI program. It's an acronym that stands for Community Safety Initiative. It is a program that I started within the first 100 days of taking office. In March of 2017 is when the program was started. With that program, the program is designed to address the issue of what we call recidivism. Recidivism means people committing crimes over and over. And so how do we address it? Well, we address it through our Community Safety Initiative. With the Community Safety Initiative, we have partnerships with agencies in our Southeast Texas area. One of the agencies that we have a partnership with is the Spindletop Center. Spindletop Center is our local mental health center. Now, what Spindletop will do, they have the expertise to address mental health needs. Spindletop will conduct private interviews either in a private room at their facility, or they can interview you by phone, whatever is convenient for you. They have the ability to do an assessment, develop a treatment plan for either outpatient or inpatient services. Now, in order to qualify for the program, you do not have to be insane or incompetent. You could just merely suffer from anxiety or depression or any other host of mental illnesses, and they have the expertise and the ability and the facilities to address your mental health needs. Spindletop also has a drug and alcohol recovery program that is called ATAR, ATAR acronym is ATAR, which stands for Addiction Treatment and Recovery. We also have a partnership with our local Drug and Alcohol Council that has a drug and alcohol recovery program that is called OSAR. OSAR stands for OSAR is OSAR, which stands for Outreach, Screening, Assessment, and Referral. Both of those programs are drug and alcohol recovery programs where they will do screenings, assessments, and they can develop plans to address your needs. They can either do your outpatient or inpatient referral services. The other thing is, if you are unemployed or if you're looking for a better job, we have a partnership with the Golden Triangle Empowerment Center. Golden Triangle Empowerment Center has a partnership with Lamar University. Lamar University has a program that is called CICE. CICE stands for Center for Innovation, Commercialization, and Entrepreneurship. It is a job training and a job placement program in the hotel industry, shipping industry, and the chemical industry. Once the individual is trained in any one of those areas that they select, then they will assist them at getting a job in the area that they're trained in. So a lot of times individuals are trained in areas, they go and try to get a job on their own. They don't get employed, but they go through this program. This program goes into the same facility and get them a job that they couldn't get on their own. That's one of the benefits of CICE. The other benefit of CICE is if for individuals who have not graduated from high school and do not have a GED, CICE has a GED program, a graduate equivalency diploma that you can receive by completing that program. Now, all of these programs that I just mentioned are free. Does not cost you anything but time. And I like to say in this court, we do not just give time, we take our time. That is, we do not just arrest the problem, we address the problem. And we believe that if we address the problem, we can produce productive people. And if we produce productive people, we believe that productive people will not, well, if we produce productive people, we'll make Jefferson County a safer place because productive people do not commit crimes. Why? Because they have too much to lose. And so I like to say that when you come to county court at law number 2, we do not just have court as usual, we have unusual court. And it's not because we're different, but because we're trying to make a difference in the lives of the individuals that come before this court. And if we make a difference in their life, we will make a difference in their home. And if we make a difference in their home, we'll make a difference in the community. Why? Because what comes out of the home goes into the community. And so if you're interested in any one of these programs that I just mentioned, just let us know because we have brochures and individuals that we can direct you to so they can give you a little bit more information about the programs that I just mentioned. Now, the other beautiful thing about this program is that all of the programs that I just mentioned can be used as a community service. So for example, let's say you was ordered to pay a fine, you couldn't pay your fine, we converted to community service. So every 1 hour that you're in job training, $12.50 is being used to pay your fine and court costs. For every 1 hour that you're in mental health treatment, $12.50 is being used to pay your community service and your fine and court costs. And so I like to tell people this all the time. You're not only killing 2 birds with one stone, you're killing 3 birds with one stone. While you're doing one thing, you're in the program, you're paying your fine and court costs, and you're doing community service, all by doing one thing. And so if you're interested in these programs, just let us know, and we'll be happy to get you involved. Now, at this time, we will have Chloe. She's from Spindletop Center. She's going to come before you and tell you a little bit more about the program that Spindletop has to offer. Chloe?
At Spindletop Center in Beaumont, Texas. The paper that I gave to each one of y'all when I came in the courtroom, it just serves as a baseline HIPAA consent form. Anything y'all put on this paper is only shared with me, and I'll be the one reaching out to you guys. A lot of people deal with mental health illnesses, not even illnesses now, say, but things like depression and anxiety. And just being honest with you guys, going through the court process can make a lot of these things, relevant in y'all's lives. So if y'all ever feel like y'all need to talk to anyone or get connected with resources, just go ahead and fill out this paper for me, and I'll be sure to talk to you guys today if needed, or contact y'all via, phone, or text or call. Also, like the judge said, there's a lot of programs that are well funded, but not easily accessible. So if y'all need assistance with anything like that, be sure to fill this out and let me know.
Okay, thank you, Chloe. Now, ladies and gentlemen, the paperwork that you have on the clipboard, we're gonna pick that up. And then we're gonna pick that paperwork up, we're gonna go through it, and then we're gonna call you up before the bench one at a time. Okay, now, it's gonna take us a little time to do that because we have quite a number of people in here. If you need to use the restroom, there are two restrooms right out there in the hall. The men's restroom is in front of County Court at Law Number 3, which is right next door to my right. And the female restroom is on the opposite, or the women's restroom is on the opposite side of the hall in front of the 172nd District Court. Now, you'll be allowed to, go out into the halls, use the restrooms, come back in. Now, do not leave the courthouse. And the reason why I say that is because if you leave the courthouse and if your name is called and you're not here, then your bond can be forfeited and a warrant can be issued for your arrest. And the other thing is this: if you need some help with the paperwork, we have our court personnel who's here who will be happy to help you with the paperwork. And I'll also be happy to help anyone with the paperwork as well. So at this time, the court is going to go into recess, and that'll give us time to pick up the paperwork. And if somebody needs help with the paperwork, just simply raise your hand, and we'll be able to come out and help you or assist you with the paperwork. So at this time, the court will be in recess. Jefferson County Code of Law number 2 is back in session. Court is in session with its arraignment docket. First case is cause number 24-CCCR 1298, case is filed in the state of Texas versus Jella and Charlotte. Right here. Miss Charlotte, your full name is Jella and Charlotte? Okay. Miss Charlotte, would you please raise your right hand? The other hand. Miss Charlotte, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Miss Charlotte, you may put your hand down. How are you doing, Miss Charlotte? Good, that's good. Now, Miss Charlotte, I have before me a document that is titled Judge's Explanation of Right to Defendants Without Attorney. Do you recognize this document? Is this your signature on the line that's titled defendant? Are these your initials on the line that state that you have a court-appointed attorney named Reagan Minaldi?
She's not a court appointed.
You hired her?
I hired her.
Okay. Now, Miss Charlotte, before you sign and initial this document, did you read the document? Did you understand what you read? Is everything in this document true and correct to the best of your knowledge? Okay, Miss Charlotte, your case is going to be reset by our court coordinator. Once you reset your case, you'll be free to go and you have a blessed day. Please have a seat in that first chair on the wall. Moises Verdejo. This is cause number 24-CCCR 1338. Case is style of state of Texas versus Moises Verdejo Chacha. Okay, Mr. Verdejo Chacha, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? You may put your hand down. How are you doing? I'm doing fine, thanks for asking. Mr. Verdejo Chacha, I have a document before me that's titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document? And is this your signature on the line that's titled defendant? And are these your initials on the line that state you'd like to hire your own attorney? Now, before you signed and initialed this document, did you read the document? Did you understand what you read? Is everything in this document true and correct to the best of your knowledge? Okay, Mr. Vero, your case is going to be reset by our court coordinator. Once your case is reset, you're free to go and you have a blessed day. Please have a seat in that first chair on the wall. Joel Angel Sanchez. Mr. Sanchez, your full name is Joel Angel Sanchez? Yeah. Mr. Sanchez, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Yes. You may put your hand down. How are you doing, Mr. Sanchez? Been better. Okay, probably been worse too, huh? Now, Mr. Sanchez, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document? Yes. Is this your signature on the line that's titled defendant? Yes. And are these your initials on the line that state you'd like to have your case reset to hire your own attorney? Yes. Okay, Mr. Sanchez, your case is going to be reset to give you an opportunity to hire your own attorney. The court coordinator is going to give you a reset. Once she gives you your reset, you'll be free to go and you have a blessed day. Please have a seat on that third chair on the wall. Next case is cause number 23-CCCR 1336. Case is style of state of Texas versus Andrew Michael III. Mr. Michael, your full name is Andrew Michael III. Yes, sir. Mr. Michael, would you please raise your right hand? Mr. Michael, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Michael, you may put your hand down. How are you doing, Mr. Michael? That's good, Mr. Michael. I have before me two documents. The first document is titled "A Judge's Explanation of Rights to Defendants Without Attorney." Do you recognize this document? Is this your signature on the line that's titled defendant? Or are these your initials on the line that state you'd like to waive your right to attorney and represent yourself?
Yes, sir.
Okay, I also have another document that is titled "Waiver of counsel for purpose of entering a guilty plea or proceeding to trial." You recognize this document? And is this your signature on the line that's titled defendant?
Yes, sir.
Now, Mr. Michael, before you sign and initial these documents that I just showed you, did you read the documents? Did you understand what you read? Is everything in these documents true and correct to the best of your knowledge? Okay, Mr. Michael, just have a seat and one of the prosecutors is gonna come out and talk to you. Just go back and have a seat where you were sitting. That's Andrew Michael. Okay.
That's the only one I gave her.
Hmm?
It's the only one I gave her.
No, she had more than that.
No, that's the only one I.
Next case is cause number 24CCCR 0584. Case is style of State of Texas versus John Pierce Chapman Jr. Mr. Chapman, your full name is John Pierce Chapman Jr.? Okay, Ms. Chapman, would you please raise your right hand? Mr. Chapman, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Chapman, you may put your hand down. How are you doing, Mr. Chapman? You doing good? That's good. Now, Mr. Chapman, I have before me a document that is titled "Judge's Explanation of Rights to Defendants Without Attorney." You recognize this document?
Sure.
Is this your signature on the line that's titled defendant?
Yes.
And or you didn't put your initials? Mr. Chapman, let me get you. You could put, you check that, you're supposed to put your initials right there. Okay, now, Mr. Chapman, are these your initials on the line that is titled, you want to waive your right to attorney and represent yourself? And I have before me a waiver of counsel for purpose of entering guilty plea or proceeding in the trial. You recognize this document? And is this your signature on the line that's titled defendant? Mr. Chapman, before you sign and initial these documents, did you read the documents? Did you understand what you read? Is everything in these documents true and correct to the best of your knowledge? Okay, Mr. Chapman, just have a seat and one of the prosecutors is gonna come out and talk to you. Next case is cause number 24CCCR 1342. Case is style of State of Texas versus Cameron Artavion Andrews. Mr. Andrews, your full name is Cameron Artavion Andrews? Mr. Andrews, would you please raise your right hand? Mr. Andrews, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Andrews, you may put your hand down. How are you doing, Mr. Andrews? I'm doing fine, thanks for asking. Now, Mr. Andrews, I have before me a document that is titled Jefferson County, that's titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document? And is this your signature on the line that's titled defendant? And are these your initials on the line that states you like to waive your right to attorney and represent yourself? I also have a document that's titled waiver counsel for purposes of entering guilty plea or proceeding trial. You recognize this document? And is this your signature on this document? Now, Mr. Andrews, before you sign in, initial these documents, did you read the documents? Did you understand what you read? Is everything in these documents true and correct to the best of your knowledge? Okay, Mr. Andrews, I read your answers. Just have a seat, and one of the prosecutors is going to come out and talk to you. Next case, actually, next four cases are cause numbers 24, John Mack.
Y'all hold down the chatter in the, up there, please.
Mr. Mack, your full name is John K. Mack? Okay, Mr. Mack, you have four cases, cause numbers 24-CCCR 1330, cause number 24-CCCR 1331, cause number 24-CCCR 1332, and cause number 24-CCCR 1585. All four cases are styled in the state of Texas versus John K. Mack. Mr. Mack, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants by Attorney. Recognize this document? Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant? Are these your initials on the line that state you'd like to apply for a court-appointed attorney? I also have another document that's titled Judge Jefferson County Affidavit of Indigence. You recognize this document? And on page 2 of the same document, there's a signature above the line that's titled defendant signature. Is this your signature? Now, Mr. Mack, before you sign and initial these documents that I just showed you, did you read the documents? Did you understand what you read? Is everything in these documents true and correct to the best of your knowledge? Mr. Mack, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney, and the attorney that will be appointed to represent you in this case is Attorney Lori Perazzo. Attorney Perazzo will be given information to contact you. You will also be given information to contact her. Our court coordinator will give you that information. Once you get that information, you'll be free to go. You have a blessed day. Now, before she gives you that information, I need the bailiff to give you a document that is titled Standard Bond Conditions and County Court at Law Number 2. I'm going to go over these bond conditions with you, and it states as follows. Following the return of criminal information in County Court at Law Number 2, all bail bonds executed for release of any defendant named herein are orders subject to the additional conditions. Number 1, the defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition? Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to test for drugs and alcohol when directed to do so, or B, submit to a test for drugs and alcohol and the test indicates the presence of drugs and alcohol in the defendant's body. Do you understand that condition? And condition, let's see. Cases. Condition number 4, condition number 3 and 4 does not apply. However, condition number 5 does apply. And condition number 5 states, defendant is prohibited from possessing a firearm or ammunition unless defendant is a peace officer as defined by section 1.07 of the Texas Penal Code, actively engaged in employment as a sworn full-time paid employee of a state agency or political subdivision. Do you understand that condition? Okay, now, Mr. Mack, if you violate any one of these conditions, your bond will be revoked, and your bonds will be revoked, and you'll be arrested and placed in the Jefferson County Jail. Now, he has a felony case, right?
I just checked it, it's September 23rd.
Okay, so these cases will be set on the same date of your felony case. Okay? Okay, just have a seat in that first chair and wait for your name to be called. Hmm?
He said he got reset,
Who is that?
Giles, client.
Ask her.
No, that's what I'm telling you, the felony got reset. 'Cause I know you asked about him this morning.
Okay, so we're resetting the misdemeanor with the felony, I guess. Okay, let's see. Next case is cause number M332-454. Case of style of state of Texas versus Cody Lee Garrett. Okay. Mr. Garrett, your full name is Cody Lee Garrett? Mr. Garrett, would you please raise your right hand? Mr. Garrett, do you swear, affirm, and tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Garrett, you may put your hand down. How are you doing, Mr. Garrett? That's good. Now, Mr. Garrett, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document? Did you hand this document to him? Do you recognize that document?
Yeah.
Is that your signature on the line that's titled defendant?
Right.
And are those your initials on the line that is titled, well, that states you want to request a court-appointed attorney? Okay, you can hand this document to him too. That document is titled Jefferson County Affidavit of Indigence. Do you recognize that document?
Yes, sir.
On page 2 of that document, there's a signature above the line that's titled defendant signature. Is that your signature? Now, Mr. Garrett, before you sign and initial these documents that was just showed to you, did you read the documents? Did you understand what you read? Is everything in these documents true and correct to the best of your knowledge? Okay, you can hand that document back to me. Mr. Garrett, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in this case is Attorney Marva Provo. Attorney Provo will be given information to contact you. You will also be given information to contact her. Our court coordinator will give you that information. Once she gives you that information, you'll be free to go. And you have a blessed day, and we'll be praying that you have a full and speedy recovery.
Thank you.
Just have a seat in that third chair. Next case is cause number 24-CCCR-0874, case of style of state of Texas versus John James Laurie. Mr. Laurie, your full name is John James Laurie?
Yes.
Mr. Laurie, would you please raise your right hand? Mr. Laurie, do you swear, affirm, to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Mr. Laurie, you may put your hand down. How are you doing, Mr. Laurie?
Better. I'm all right.
Okay, I'm sure you've been worse too, huh?
Yes, sir.
All right, now, Mr. Laurie, I have before me a document, or two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. And you recognize this document?
Yes.
Is this your signature on the line entitled defendant? Are these your initials on the line that state you'd like to apply for court-appointed attorney? I also have another document that is titled Jefferson County Affidavit of English. You recognize this document?
Yes.
On page 2 of the same document, there's a signature above the line that's titled defendant signature. Is that your signature?
Yes.
Now, Mr. Laura, before you sign and initial these documents that I just showed you, did you read the documents?
Yes.
Did you understand what you read?
Yes.
And is everything in these documents true and correct to the best of your knowledge?
Yes.
Mr. Laura, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. The attorney that's appointed to represent you is Nathan Reynolds. Mr. Reynolds will be given information to contact you. You'll also be given information to contact him. Our court coordinator will give you that information. Once she gives you that information, you're free to go and you have a blessed day.
Yes.
Please have a seat in that third chair on the wall. Next case is cause number 24-CCCR-1282, case of style of state of Texas versus Robert Jefferson Leach. Good morning. Mr. Leach, your full name is Robert Jefferson Leach?
It is.
Okay, Mr. Leach, would you please raise your right hand? Mr. Leach, do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Leach, you may put your hand down. How are you doing, Mr. Leach?
Outstanding. How about you?
I'm doing great. Thanks for asking. Now, Mr. Leach, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes.
And on the next document, well, let me do this here. Are these your initials on the line that state you'd like to apply for court-appointed attorney?
It is.
And is this your signature on the line that's titled defendant?
It is.
I also have another document that is titled Jefferson County Affidavit of Industries. Recognize this document?
Yes.
And on page 2 of this same document, there's a signature above the line that is titled defendant signature. Is this your signature?
It is.
Mr. Leach, before you sign and initial these documents that I just showed you, did you read the documents? Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge?
It is.
Okay, Mr. Leach, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in this case is Attorney Charles Rojas. Attorney Rojas will be given information to contact you, and you will be given information to contact him. Our court coordinator will give you that information. Once she gives you that information, you'll be free to go, and you have a blessed day. Please have a seat in that 5th chair on the wall. Okay, Jimmy Menifee. Okay. Mr. Menifee, your full name is Jimmy Ray Menifee? Mr. Menifee, would you please raise your right hand? You swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Menifee, you may put your hand down. How are you doing, Mr. Menifee?
I'm fine.
I'm doing fine. Thanks for asking. Mr. Menifee, I have before me 2 documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. Recognize this document? Yeah. And is this your signature on the line that's titled defendant?
Yes.
Or these your initials on the line state you'd like to apply for court-appointed attorney? I also have another document that is titled Jefferson County Affidavit of Industries. Do you recognize this document? On page 2 of the same document, there's a signature above the line that's titled defendant signature. Is this your signature? Now, Mr. Menifee, before you sign and initial these documents that I just showed you, did you read the documents? Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge? Mr. Menifee, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney, and the attorney that will be appointed to represent you in this case is Attorney Joel Vasquez. Attorney Vasquez will be given information to contact you, and you will be given information to contact him. Our court coordinator will give you that information. Once she gives you that information, you'll be free to go, and you have a blessed day. Please have a seat at that table right there. Yeah. Yeah. Next case is, Jaquisha Bernard. Ms. Bernard, your full name is Jaquisha Bernard. Ms. Bernard, would you please raise your right hand? Ms. Bernard, do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Ms. Bernard, you may put your hand down. How are you doing, Ms. Bernard? You doing good? That's good. Now, Ms. Bernard, I have before me 2 documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document? Is this your signature on the line that's titled defendant? Or these your initials on the line that state you'd like to apply for a court-appointed attorney? I also have another document that's titled Jefferson County Affidavit of Indigence. Recognize this document? On page 2 of the same document, There's a signature above the line, it's got a defend the signatures, that's your signature. Now, Ms. Bernard, before you signed and initialed these documents, did you read the documents? Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge? Okay, Ms. Bernard, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of court-appointed attorney. And the attorney that will be appointed to represent you is Attorney William Wilkerson. Attorney Wilkerson will give information to contact you, and you will also be given information to contact him. Our court coordinator will give you that information. Once she gives you that information, you'll be free to go. You have a blessed day. Please have a seat in that first chair on the wall. Kendrick Booker. Huh? Yeah, well, she's working on one right now. They're not ready yet. Now, this is cause number 24 CCCR 0156. Case is style of state of Texas versus Kendrick Booker. And Mr. Booker, is that your full name?
Yes.
Now, Mr. Booker, I have before me two documents. The first document was titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes.
Is this your signature on the line to cite a defendant?
Yes.
Or these your initials on the line state you'd like to apply for court-appointed attorney?
Yes.
I also have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document?
Yes.
And on page 2 of this document, there's a signature above the line that's titled Defendant Signature. Is this your signature?
Yes.
Now, Mr. Booker, before you signed and initialed these documents that I just showed you, did you read the documents?
Yes.
Did you understand what you read?
Yes.
And is everything in these documents true and correct to the best of your knowledge?
Yes.
Now, Mr. Booker, let's see, before we go any further, let me do this here pursuant to Article 1.2 for the right to public trial. The defendant is entitled to public trial in all proceedings and cases in the court. However, pursuant to the case of Lilly versus State 365 Southwest Third, the right to public trial is not absolute and may be outweighed by other competing interests, such as the interest in security, to ensure that the defendant get a fair trial and to prevent the disclosure of non-public information. The court is going to ask Mr. Booker some questions that is should be non-public information. And so at this time, the court has considered other reasonable alternatives. The court believes that, now, Mr. Booker, I'm going to ask you some information about your finances. Now, the right to a public trial, you have a right to a public trial of proceedings in the court. However, that's not an absolute right. And what that means is you can waive it, and the reason why you can waive it is because pursuant to a case versus Lilly versus State 365, 321, it says the right to public trial is not absolute and may be outweighed by other competing interests, such as the non-disclosure of public information. So, or the disclosure of non-public information. So your information that I'm gonna ask you regarding your finances is not public. Do you understand? So we can close these proceedings and I can ask you some questions about your finance so that no one else would be able to hear what your finances are. And or if you don't mind them hearing your non-public information, that's up to you. So would you like this proceeding closed to the public?
Proceed.
Okay, you don't mind? Okay. Well, just an abundance of caution, I'm going to, we're gonna go off of YouTube. We're on YouTube right now. So at this time, Mr. Booker, the court finds that you do not meet the eligibility requirements for the appointment of a court-appointed attorney. Let me see, this is 8/13/24. Okay. Now, at this point, you could do one of two things. You know, originally I said you had three options. One, you can hire. Two, if you did not have enough money, you can request a court-appointed attorney. And three, you can waive your right to an attorney and represent yourself. Now, you do not qualify, so the other two options are still on the table. You can request time to hire an attorney, or you can waive your right to an attorney and represent yourself. Okay, let me do this here. Ms. Mosley,
Yes, sir.
could you hand this document back to Mr. Booker? He needs to strike a line through there, and then he's gonna put his initial on the first line. He needs a pen.
Oh,
Yeah, you just gonna strike it out.
you doing the first one?
Yeah, he says he wants to hire an attorney. Okay. Okay. Now, Mr. Booker, you have your initials on the line that says you want your case reset to hire your own attorney. Is that correct? Now, your case is gonna be reset to give you an opportunity to hire an attorney. But before your case is reset, the bailiff is going to hand you a document that is titled Standard Bond Conditions and County Court at Law. Number two, I'm going to go over these bond conditions with you. And it states as follows: Standard Bond Conditions and County Court at Law number 2. Following the return of a criminal information in County Court at Law number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein are ordered subject to the additional conditions. Number 1, the defendant shall commit no offense against the laws of this state, any other state, or the United States. Do you understand that condition? Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so, or B, submit to a test and the test indicates the presence of drugs and alcohol in the defendant's body. Do you understand that condition? And condition 3 and 4 does not apply. However, condition number 5 does apply. And condition number 5 states the defendant is prohibited from possessing a firearm or ammunition unless the defendant is a peace officer as defined by section 1.07 of the Penal Code, actively engaged in employment as a sworn, full-time, paid employee of a state agency or political subdivision. Do you understand that condition? Now, Mr. Booker, if you violate any one of these bond conditions, your bond can be revoked. And if your bond is revoked, the warrant will be issued for your arrest. You'll be arrested and placed in the Jefferson County Jail. Now, Mr. Booker, just have a seat at that table and wait for your name to call. Once your name is called, you're free to go and you have a blessed day. Gregory Wayne Lewis. Mr. Lewis, your full name is Gregory Wayne Lewis. Mr. Lewis, would you please raise your right hand? Mr. Lewis, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Lewis, you can put your hand down. How are you doing, Mr. Lewis? That's good. Now, Mr. Lewis, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yeah.
And is this your signature on the line that's titled Defendant? And are these your initials on the line that state you would like to have your case reset to hire your own attorney? Now, Mr. Lewis, before you sign and initial this document, did you read the document?
Yes.
Did you understand what you read? And is everything in this document true and correct to the best of your knowledge? Okay, Mr. Lewis, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will appoint it to represent you is, well, no.
No.
Let me see, Mr. Lewis, I made a mistake. Mr. Lewis, your case will be reset to give you opportunity to hire your own attorney. Okay? And before your case is reset, I need to give you some bond conditions, the attorney, you know, the bailiff is gonna give you some standard bond conditions that I'm going to go over with you, okay? Now, it's titled Standard Bond Conditions in County Court at Law number 2. Do you see that title?
Yes, sir.
And it states as follows: following the return of a criminal information in County Court at Law number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein are ordered subject to the additional conditions. Number 1, the defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition?
Yes, sir.
Condition number 2, the defendant shall submit to testing of drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test of drugs and alcohol when directed to do so by the court, or B, submit to a test of drugs and alcohol, and the test in the case of presence of drugs and alcohol in the defendant's body. Do you understand that condition? And condition number 3 and 4 does not apply. However, condition number 5 does apply and states that the defendant is prohibited from possessing a firearm ammunition unless the defendant is a peace officer as defined by section 1.07 of the Texas Penal Code, actively engaged in employment as a full-time sworn paid employee of a state agency or political subdivision. Do you understand that condition?
Yes.
Okay, now, Mr. Lewis, if you violate any one of these conditions, your bond will be revoked, and if your bond is revoked, a warrant will be issued for your arrest. And Mr. Lewis, you're gonna have a seat in the jury box. Follow the directions of the bailiff. You have a felony warrant. Okay? Felony warrant for your arrest, okay? Okay, what are you talking about?
Cause it's on the same person.
This is misdemeanor. He has a felony,
No, but it's on a thing.
unless he got a misdemeanor charge.
Yeah, look at that. It's in the same case.
Where it's unlawfully carrying a weapon. I don't know. You're gonna have to check it out. Just bring him in the back, check it out, see if it was, I see it was, this bond was posted. I don't know, you just look into it. Wait, a minute, they got, yeah. Does he have a, let me see, is his case a -1 or -2? Or is this,
No,
his just don't have a -1 in it? Must be a co-defendant, huh?
I don't know, but that's the same case.
Yeah, you can
That
take him
he's
in,
here
you can
for.
find out, look into it. They're gonna look into it. You may or may not, she's gonna check into it. That's to verify it. Okay. Okay. Well, you could bring it on up. Okay. Let's see. This is cause number M333-240, cases filed in the state of Texas versus Daquila. What's it, HL?
Marshall.
Arshel Renfro. Ms. Renfro, would you please raise your right hand? Ms. Renfro, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, self you got? Ms. Renfro, you may put your hand down. How are you doing, Ms. Renfro? I'm doing fine. Thanks for asking, Ms. Renfro. I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. Ms. Renfro, do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defender?
Yes, sir.
And are these your initials on the line that state you'd like to apply for court-appointed attorney? I also have another document that's titled Jefferson County Affidavit of Indigence. Do you recognize this document? On page 2 of the same document, there is a signature above the line that's titled Defender Signature. Is this your signature?
Yes, sir.
Now, Ms. Renfro, before you sign and initial these documents that I just showed you, did you read the documents?
Yes, sir.
Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge?
Yes.
Ms. Renfro, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in this case is Attorney Langston Adams. Attorney Adams will be given information to contact you, and you will be given information to contact him. Our court coordinator will give you that information. Once you get the information from the court coordinator, you'll be free to go and you have a blessed day. Ms. Renfro, just please have a seat in that fifth chair on the wall.
You have a blessed day.
All right, thank you. Court will be in recess. Nothing but the truth to help you God? Mr. Chapman, you may put your hand down. And Mr. Chapman, I have before me a document that I showed you earlier. This document is titled Judge's Explanation of Rights to Defendants Without Attorney. Again, do you recognize this document? And these are your initials on the line that state you want to waive your right to an attorney and represent yourself. And this is your signature on the line that's titled defendant. I also have another document that's titled Waiver of Counsel for Purposes of Entering Guilty Plea Proceeding to Trial. And is this your signature on the line that's titled defendant? And previously you acknowledged that you recognize these documents and that these are your initials and signatures on these documents. And you read these documents, understood everything that you read, and everything in these documents are true and correct to the best of your knowledge. Is that correct? Now, Mr. Chapman, I have before me on my computer a document that is titled information. This information was filed by the Jefferson County District Attorney's Office. In this information, Mr. Chapman, it alleges that you committed a Class A misdemeanor offense of driving while intoxicated when the alcohol concentration level of 0.15 or more. However, state, are you abandoning the enhancement paragraph?
Yes, Your Honor.
Now, the state is abandoning the enhancement paragraph. What that means is, instead of being charged with a higher Class A misdemeanor, you'll be charged with a lower offense, a Class B misdemeanor offense, a DWI. Do you understand that? Okay, and Mr. Chapman, I forgot to mention, do you waive a record in this case? All right, now, Mr. Chapman, I also have before me a document that is titled Misdemeanor Plea Admonishments. This is also listed as State's Exhibit Number 1. Do you recognize this document? On page 2 of this same document, there's a set of initials on a line next to a box. Now, Mr. Chapman, before I do that, Mr. Chapman, this information alleges that on or about December 26th of 2023, while you were in Jefferson County, Texas, operating a motor vehicle in a public place in Jefferson County, Texas, that you committed to Class B misdemeanor offense of driving while intoxicated. Mr. Chapman, do you understand what you've been charged with? And to this charge, Mr. Chapman, how do you plead? Guilty, not guilty, no contest? No contest. Now, Mr. Chapman, I also have before me in State's Exhibit 1 that I just showed you on page 2, there are 2 sets of initials. One set of initials is below a paragraph that is titled waiver, and it's on a line next to a box that's checked nolla contendere, which means no contest. Did you place your initials on this document?
Yes.
And the second set of initials is below a paragraph that is titled discovery admonishment. The initials are on a line next to a statement that states as follows. I do not request discovery of the evidence. I have waived my right to request discovery in this case and choose to enter a plea of guilty or no contest. Mr. Chapman, did you place your initials on this document? On page 3 of the same document, there's a signature above the line that is titled defendant. Is this your signature?
Yeah.
Now, Mr. Chapman, before you signed, well, Mr. Chapman also have another document that's titled Trial Court Certification of Defendant's Right of Appeal. Do you recognize this document? And is this your signature on the line that's titled defendant? At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. You understand that statement? The second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement? Now, Mr. Chapman, before you sign and initial all of the documents that I just showed you, did you read the documents?
Yes.
And did you understand what you read? And is everything in these documents true and correct to the best of your knowledge? Mr. Chapman, are you a citizen of the United States?
State Upper States 1.
Mr. Chapman, the state is offering State's Exhibit Number 1 to be used as evidence in your case. Now, State's Exhibit Number 1 is the first document that I showed you on this tablet. And this is the same document that have your initials in the 2 locations on page 2 and your signature that you acknowledged on page 3. The state would like to use this document as evidence in your case. Is it all right for the state to use this document? Okay, no objection. State's Exhibit Number 1 will be admitted. Mr. Chapman, is there any evidence that you are currently mentally incompetent to stand trial? Mr. Chapman, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given, and I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
Yes, Your Honor.
And what is the agreement?
In exchange for defendant's plea, the state's offering 1 year deferred probation, $500 fine, 50 hours community service, interlock DWI standard conditions of probation plus court costs.
What is this court cost? Okay, Mr. Chapman, the state is offering that you serve 1 year deferred adjudicated probation. During the 1 year probationary period, you'll be required to pay a fine of $500 plus a DPS conviction fine of $100. You will also be required to pay court costs of $392, probation fee of $60 a month, your analysis fee of $15 a month, and reimbursement fee of $15. Your total monthly installments, that is the total amount that you'll be required to pay each month is $173 a month. Will you be able to pay the $173 a month? You'll also be required to pay Jefferson County DWI initial evaluation fee of $125 on the day of plea. Should a further evaluation be needed, you'll be required to pay an additional $50. Now, Mr. Chapman, you will also be required to perform 50 hours of community service. You must have an interlock device or any vehicle that you own or operate. You must attend and complete a DWI education class. You are required to have an alcohol assessment, and you will be required to adhere to the other standard terms and conditions of DWI probation. Mr. Chapman, do you understand the state's offering? Do you think that the state's offering in your case is fair and just? And do you accept the state's offer? Mr. Chapman, I follow the people are in agreement that you have entered into with the state. Now, Mr. Chapman, if you successfully complete this probationary period, this case will be dismissed. It will not result in a conviction on your record, and you may qualify for a non-disclosure. You can talk to your attorney or talk to an attorney about the non-disclosure. Okay, now, Mr. Chapman, please stand next to the bailiff, follow her directions. No. Who? Andrew Michael?
Oh, no, I think she needs the paperwork. No, the paperwork.
Oh,
I'm sorry.
you said Andrew.
Yeah, no.
Oh.
Almost.
You say send him to you.
No.
Send Andrew Michael to me.
My bad. You know what I'm doing.
No, I didn't.
Okay.
That's why. Okay, I'm gonna send it to you right now. Can I call him up?
Yeah.
Andrew Michael III. Okay, this is cause number 23CCCR 1336, case of style of state of Texas versus Andrew Michael III. Mr. Michael, is that your full name? Mr. Michael, would you please raise your right hand? Mr. Michael, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Michael, you may put your hand down. Again, Mr. Michael, how are you doing? That's good. Mr. Michael, I have before me two documents that I have before me. One state is titled Jefferson County, well, it's titled Judge's Explanation of Rights to Defendants Without an Attorney. You recognize this document? And again, this your signature on the line is titled Defendant. And all these your initials on the line is titled, that state you like to waive your right to attorney and represent yourself. Yes. Okay, and this is another document that's titled Waiver of Counsel for purposes of entering guilty plea or proceeding to trial. You recognize this document? And is this your signature on the line is titled Defendant? Okay. Now, before you sign and initial these documents, you read these documents, is that correct? And you understood what you read? And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Now, Mr. Michael, I also have before we get started, you have a right to have a record of this proceeding. Do you waive or give up your right to have a record?
Yes, sir.
Okay. Now, Mr. Michael, I also have before me a document that is titled Information Sheet. This information sheet is on my computer. This information sheet was filed by the Jefferson County District Attorney's Office. In this information sheet, it alleges that you, Andrew Michael III, on or about April 3rd of 2023, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense of unlawfully carrying a weapon. Send Chapman back to me. Do you understand what you've been charged with?
Yes, sir.
There should be an arrow back. Now, Mr. Chapman. Mr. Michael. I also have before me, I need you to send Chapman back to me, but I'm talking to Mr. Michael on another case. Now, Mr. Michael, I also have before me a document that is titled Misdemeanor Plea Admonishment. It is also labeled as State's Exhibit Number 1. Do you recognize this document? Let me get this. Okay.
You got it.
You recognize that document?
Sure.
Now, let me do this. On page 2 of the same document, there's a set of initials on a line. There are 2 sets of initials. First set of initials are on a line next to a box that's checked no continuing, which means no contest. Did you place your initials on this document?
No content?
Yes.
Yes, sir.
And the second set of initials is below a paragraph that is titled Discovery Admonishment, and it's next to a statement that states as follows: I do not request discovery of the evidence. I waive my right to request discovery in this case and choose to enter a plea of guilty or no contest. You place your initials on this document as well. Speak up. Okay, on page 3 of the same document, there's a signature above the line that is titled Defendant. Is this your signature?
Yes, sir.
And on the next document that's titled Trial Court Certification of Defendant's Right of Appeal, do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Sure.
At the top of this document, there's 2 boxes checked. The first box checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement? Yes, speak up.
Yes, sir.
The second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement? Now, Mr. Michael, before you sign and initial all of these documents that I just showed you, did you read the documents? Do you understand what you read?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Sir.
Okay. Mr. Michael, are you a citizen of the United States? You have to speak up.
Yes, sir.
State offer states one.
Now, the state is offering State's Exhibit Number 1 to be used as evidence in your case. State's Exhibit Number 1 is the first document that I showed you on the tablet, or that she showed you. And this is the same document that have your initials in the 2 locations on page 2. And the same document has your initials, your signature at the top. The state would like to use this document as evidence in your case. Is it all right for the state to use this document as evidence in your case?
Yes, sir.
Okay, no objections? State's exhibit number 1 will be omitted. And, again, Mr. Michael, you are a citizen of the United States? Okay, state,
State offers same.
states 1, no objection, state's exhibit number 1 will be omitted. Now, Mr. Michael, is there any evidence that you are currently mentally incompetent to stand trial? Okay, no objection, okay. Mr. Michael, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that there is sufficient evidence to find you guilty beyond a reason that I also find that your waiver was freely and voluntarily given. State, do we have a pre-board agreement? And what is that agreement?
In exchange for sentence plea, the state's offering 6 months deferred, $250 fine, 24 hours community service, plus forfeiture of the weapon to the Beaumont Police Department.
So 250, just 250 for one time?
It will explain it to you. It's gonna be within your probation.
What is this court cost?
277.
What, 6 months? Deferred. Okay, Mr. Michael. State is offering that you serve 6 months of further adjudicated probation during the 6-month probationary period. You'll be required to pay a fine of $250 plus court costs of $277 plus probation fee of $6 a month, your analysis fee, $15 a month, and a reimbursement fee of $15.
Yes, I ain't.
Okay, I'm explaining it. I'm gonna
Money.
give you a total. Yeah, you don't have to add it up. I'm adding it up for you. Okay?
Man, you going fast though.
Okay. Okay, the same numbers that I've given to you is gonna be on the paperwork. Okay? So, your fine is $250 plus court costs. The court cost is $277. Your probation fee is $60 a month. Your, you'll also be required to pay your analysis fee of $15 a month and reimbursement fee of $15. Your total monthly installments, that is the total amount that you will be required to pay each month, is $198 a month. Will you be able to pay the $198 each month?
Along with what else a month? Just that?
That's all I said.
I could pay 198 a month.
Okay, that was my question. So, now you also be required to perform 24 hours of community service. You, the state is also requiring that you forfeit the weapon to, is it the Beaumont Police
Yes,
Department?
Your Honor.
To the Beaumont Police Department, and you will be required to adhere to the other standard terms and conditions of your probation. And I have before me a document that is titled Forfeit Your Weapon. Do you recognize this document? A motion of forfeit. Is this your signature on the line that's titled Defendant? Now, Mr. Michael, before you signed this document, did you read the document? Did you understand what you read? And is everything in this document true and correct to the best of your knowledge?
Yes, sir.
Okay, Mr. Michael, I read, okay, Mr. Michael, do you well, what I'm going to do, I'm signing the motion to grant a motion, granting the motion to forfeit the weapon to the Beaumont Police Department. Okay, I just signed the motion to forfeit the weapon to the Beaumont Police Department. Mr. Michael, do you understand the state's offer?
They already have their witness. I never got it back.
They're gonna keep it.
Yeah, that's true.
You know, we can't, don't take it from you, I mean. Unless they have the weapon. So, now. Do you understand the state's offer? Do you, think that the state's offer in your case is fair and just?
Yes, yes, sir.
Do you accept the state's offer?
Yes, sir.
Okay, I'll follow the plea bargain agreement that you have entered into with the state. Mr. Michael, if you successfully complete this probationary period, you may qualify for non-disclosure. You'd have to talk to an attorney about that. This will conclude your case. This case will not result in a conviction on your record if you successfully complete this probationary period. You understand that? Okay. You're gonna have a seat in the, you have this paperwork? Okay, you're gonna stand in front of the court coordinator. You're gonna follow the directions of the bailiff. Once you finish following her directions, you're free to go and you have a blessed day.
Okay. There you go.
You know where to go? You know where to go?
Did you see me?
See, he said he don't know where to go.
School.
Okay, let me, you know, okay. This is, cause number 24 CCCR 1342, case is styled the state of Texas versus Cameron Tavion Andrews. Mr. Andrews, is that your full name? Mr. Andrews, would you please raise your right hand? Mr. Andrews, do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Andrews, you may put your hand down. How are you doing, Mr. Andrews? That's good. Now, Mr. Andrews, I have before me, two documents. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document? And is this your signature on the line that's titled Defendant? And are these your initials on the line that state you want to waive your right to an attorney and represent yourself? I also have another document that is titled Waiver of Counsel for Purposes of Inter Guilty Plea Proceeding in Trial. You recognize this document? And is this your signature on the line that's titled Defendant? Okay, now before you sign and initial these documents, did you read the documents? Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge? Yeah. And Mr. Andrews, I also have before me a document that is titled information. This information is on my computer. This document was filed by the Jefferson County District Attorney's Office. In this document, Mr. Andrews, it alleges that you, Cameron Tavion Andrews, on or about April 26th of 2024, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense of unlawfully carrying a weapon. Do you understand what you've been charged with?
Yes, sir.
And to this charge, how do you plead? Guilty, not guilty, no contest? Now, you're pleading no contest freely and voluntarily? And are you pleading no contest because you do not wish to fight or contest the charges?
Yeah, he did plead guilty, Judge. I don't know if he wants
Oh.
to change it.
Oh,
Or you
now
want-
you pleading guilty or no contest?
Mm-hmm.
Okay, no problem. Hold on a minute. You just need to change that.
Be on the first page as well.
No, it's just that one spot, huh?
On the first page at the very top, you put no guilty or contest as well.
Oh, it does?
Here, Judge, right here.
Oh, you're talking about the form, plea form. And so you have to change that. Hmm? Gregory Lewis?
Know what you mean.
Here you go, Judge.
Oh,
Yeah, right.
okay. Now, Mr. Andrews, let me do this again. I have before me an information that was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, Cameron Ortavian Andrews, on or about April 26th of 2024, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense of unlawfully carrying a weapon.
Mhm.
Do you understand what you have been charged with?
Yes, sir.
And to this charge, how do you plead? Guilty, not guilty, no contest?
No contest.
Now, you pleaded no contest freely and voluntarily. No, you pleaded no contest because you do not wish to fight or contest the charges. Mr. Andrews, I also have before me on this tablet a document that is titled Misdemeanor Plea Admonishments, which is also labeled as State's Exhibit Number 1. Do you recognize this document?
Yes, sir.
On page 2 of this same document, there are 2 sets of initials. First set of initials is below a paragraph that is titled Waiver, and the initials are on a line next to a box that's titled, or that's checked, Nola Contendere, which means no contest. Did you place your initials in this location?
Yes, sir.
Now, the second set of initials are located below a paragraph that is titled Discovery Admonishment. And it's next to a line that states, I do not request discovery of the evidence. I waive my right to request discovery in this case and choose to enter a plea of guilty or no contest. Did you place your initials on this document?
Yes, sir.
On page 3 of this same document, there's a signature above the line that is titled Defendant. Is this your signature?
Yes, sir.
And on the next document that's titled Trial Court Certification of the Defendant's Right of Appeal, you recognize this document? And is this your signature on the line that's titled Defendant? At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement? The second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement? Now, Mr. Andrews, before you signed and initialed all of these documents that I just showed you, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Okay. Now, before we go any further, did I ask you, you want to waive your right to a record in this case? Which means that you have a right to have, remember earlier I said you had a right to have a court reporter to dictate or type everything that's being said. However, you also have a right to waive or give up that right. You waive it? Okay. Now, are you a citizen of the United States?
State
State.
overstates one.
Now, the state is offering State's Exhibit Number 1. Again, I'm gonna show you, this is State's Exhibit Number 1, the misdemeanor plea admonishment. Same document that have your initials in 2 locations, and the same document that has your signature on page 3. State would like to use this document as evidence in your case. Is it all right for the state to use this document? Is there, okay, no objections? State's Exhibit Number 1 will be admitted Mr. Andrews, is there any evidence that you're currently mentally incompetent to stand trial? Do you have any mental issues or mental conditions that affect your ability to understand what you've been charged with, the consequences of your plea? Okay. Now, Mr. Andrews, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
Yes, Your Honor.
And what is the agreement?
In exchange for defendant's plea, the state's offering 6 months deferred, $100 fine, 30 hours community service, and forfeiture of the weapon to the Belmont Police Department.
What's it for cost?
277.
Okay. Now, Mr. Andrews, the state is offering that you serve 6 months deferred adjudicated probation during the 6-month probationary period. You'll be required to pay a fine of $100, plus court costs of $277, plus a probation fee of $60 a month, your analysis fee of $15 a month, reimbursement fee of $15. Your total monthly installments, that is the total amount that you will be required to pay each month, is $168 a month. Will you be able to pay the $168 a month? You'll also be required to perform 30 hours of community service. You will forfeit the weapon, in this case, to the Beaumont Police Department.
That mean I don't have a chance to get my gun back?
Yes,
I'm trying to see, do I gotta sign that paper?
that's part of the plea bargain. That's that's part of the plea bargain that the state has made to you. Okay? Now, I have before me a motion to forfeit the weapon to the Beaumont Police Department. Do you recognize this document?
Yes, sir.
And is this your signature on this document?
Yes.
Now, before you signed this document, did you read the document?
Yes, sir.
Did you understand what you read? And is everything in this document true and correct to the best of your knowledge?
Yes, sir.
And you're requesting that this court grant this motion to forfeit? Okay, the court is granting the motion to forfeit the weapon to the Beaumont Police Department. Okay, now, Mr. Andrews, do you understand the state's offer?
Yes, sir.
You think the state's offer in your case is fair and just?
Yes, sir.
And do you accept the state's offer? Mr. Andrews, I'll follow the plea bargain agreement that you have entered into with the state. Now, Mr. Andrews, this will conclude your case. Now, Mr. Andrews, if you successfully complete this probationary period, this case will be dismissed. It will not result in conviction on your record, and you may qualify for non-disclosure. You can talk to an attorney about the non-disclosure. Now, Mr. Andrews, please stand in front of the court coordinator, follow the directions of the bailiff. Once you finish following her directions, you're free to go, and you have a blessed day. You're welcome. Okay. Jefferson County Court, law number 2 is back in session. The court is in session and, with the arraignment docket again. Court is in session and calls number 23 CCCR 0252, case of style, State of Texas versus Tajana or Tawana Michelle White. Ms. White was scheduled to be in court this morning at 9 a.m. At about 9 a.m., court's bailiff called the name of Tajana or Tawana White at the courthouse door. Ms. White did not answer. Ms. White has not appeared in court since the court has been in session. The time now is 12:44 p.m. on today's date of August 13th of 2024. Ms. Bailiff, would you please call the name of Tajana White or Tawana White at the courthouse door? No, okay. There's been no answer. Tajana or Tawana White did not answer when her name was just called again at the courthouse door by the court's bailiff. Tawana or Tajana White has been given a reasonable time to appear in court. She has not appeared in court. State, do you have a motion?
Statements one holster.
That motion will be granted. Tawana or Tajana White bond will be forfeited and cause number 23 CCCR 0252. Next two cases are cause number 24 CCCR 1000 and cause number 24 CCCR 1448. Case is style of State of Texas versus Caesar Israel Ixcoy Lobos. Mr. Ixcoy Lobos was scheduled to be in court this morning at 9 a.m. At about 9 a.m., the court's bailiff called the name of Caesar Ixcoy Lobos at the courthouse door. Caesar Ixcoy Lobos did not answer. A reasonable time has passed to give him an opportunity to appear in court. He's not appearing in court. The time now is 12:46 p.m. on today's date of August 13, 2024. Ms. Bailiff, would you please call the name of Caesar Ixcoy Lobos at the courthouse door? Caesar Ixcoy Lobos' name was just called again at the courthouse door by the court's bailiff. He did not answer. Has not appeared in court since the court's been in session. A reasonable time has passed to give him an opportunity to appear in court. State, do you have a motion?
Statements one holster.
Those motions will be granted. Caesar Ixcoy Lobos bond will be forfeited and warrant should be supervised arrest and cause numbers 24 CCCR 1000 and cause number 24 CCCR 1448. All. Okay, then this will conclude the calling of the court's docket, the court's arraignment docket on today's date of August 13th, 2024 in County Court at Law number 2, Jefferson County, Texas. Everyone, please have a blessed day. Prosecutors, you are excused.
Thank you, Judge.
Okay.